afternoon. Thank you all for joining us today in the LegitClass. I am Tulip, moderator for this session, and I am deeply honored to have Mr. Sharma, advocate, as our esteemed speaker. Thank you all for joining us today in this LegitClass. Mr. Sharma is a litigator par excellence and brings over 3 decades of experience in the field of litigation and dispute resolution. He established Prosoll Law Inc, a prominent firm dealing in matters pertaining to anti-corruption laws, comprising trap cases, bank frauds, disproportionate assets, cheating, forgery, and other economic offences. The firm has since establishment served a wide range of clients ranging from bureaucrats and high-ranking officials of various government and non-government departments to politicians, high net worth families and individuals, institutions, and NGOs. Mr. Sharma carries several important reported judgments and landmark decisions to his credit and has been at the forefront of several high-profile and high-stake litigations. He is one of the top preference in matters pertaining to financial fraud, money laundering, corruption, extradition, bribery, and other abstruse areas, and is regarded in high esteem by clients, peers, and fellow members of the fraternity for his oratory skills in court as well as excellent drafting. Today's lecture class is on Prevention of Corruption Act Amendment and its applicability. This class is organized by Legitquest, which is an artificial intelligence-based legal research product. It is a state-of-the-art legal research platform for conducting legal research and is very well known for the introduction of the world's only one-click insight system called the iDraft Case Analytics. In short, the iDraft feature powered by artificial intelligence takes out the issue, facts, arguments, reasoning, and decision of a case law. Legitquest recently has also started with LegitEye, which has latest news, interviews, columns, and serves the stakeholders of judiciary. Our today's session will be for 45 minutes, followed by a Q&A session. I would request all our participants to be on mute and without video throughout the session. And all questions to the speaker can be written in the chat box, which will be taken at the end of the session if time permits. I would now hand it over to Harsh sir. So please.
Friends, I believe everybody is getting quiet. Good evening. Prevention of Corruption Act started as originally around 1860. That was section 161, 160 part of, and that was from that was done in Corruption Act or provision relating to corruption. It was done in 1947, divided or 2, and brought into fora. Subsequently, it amended twice. 1947 it amended twice, once in 1952, and thereafter, after the Senate committee has come up, it was thereafter amended in 1964. In between, there is one amendment I will not touch at this time. It only relate to section 5(1)(e) itself. It was introduced and it was taken back. It was reintroduced in 1964. However, after 1964, a lot of legwork was done by legislatures, by various institutions. Research was done how to improve upon bribery and how to control bribery. But my friends, after 160 years, it was amends in 1860 also, and it's amends in 2020 also. But whatever may be. 47 Act of Prevention of Corruption Act was amended in 1988. It was a substantial amendment. Particularly, the definition of public servant was got, which was earlier limited to the concept of having employment. It was taken away from that concept. It was then assigned to a post, which anybody could have. Now, understand this. A minister holding a portfolio is not appointed to its post as legislature, but it becomes a public servant under PC Act 1988. Though there exists no master-servant relationship whenever ministers is there, but in 1988, this concept is introduced and it is still doing the same. Thereafter, lately, 2018 was a crucial year. On 26th July, we have I use the word, use it because legislature thought proper change in the form of amendment in PC Act. Effect of those amendments I'll discuss shortly. But please understand, the idea was to bring and enhance the scope of Corruption Act as far as possible. But what I will just narrate to you, I think this amendment is something otherwise. I'll explain to you how. In 1988, if there is a public servant who stood retired from a post, and you have to file a charge sheet against him, or you have to do something, he was not required to take. Has been substituted word is and was. Is and was says anybody after 26th July 2018, anybody who is a public servant may be in the post, may not be in the post. In case a charge sheet has been filed against him or must could be the appointing or removing authority of that servant. No 17A to give a test. Where do you stand now? Qua PC Act existing in 1988, Section 17A, it has been for the first time it has been introduced. I'll give you a little background of this act also, why it has been introduced. It says inquiry related to recommendation made or decision taken by public discharge of official functions or duties. No police officer shall conduct an inquiry or investigation into any offence alleged to have been committed by public servant under this act. If the alleged offence is relatable to any servant in discharge of his official functions or duty without previous approval of 1. In the case of a person who is or was employed at the time when the offence alleged to have been committed in connection with the affairs of the union to that government. B. In case of a person who is or was employed at the time when the offence is alleged to have been committed in connection with the affairs of a state of that government. C. In case of any other person of the authority competent to remove him from his office at the time when the offence is alleged to have been committed, provided no such approval shall be necessary for the cases involving arrest of a person on spot on charge of accepting or attempting to accept undue advantage. Further, concerned or section within a period of 3 months, which may for the reasons to be recorded in writing by such authority to be extended by a further period of 1 month. I'll give you a background of this. Originally, way back, there used to be a single directive.
Excuse me, sir, sorry for interrupting you right now. Actually, your voice is breaking. I think the network bandwidth is low. So maybe if you could stop the video, the audio would be
I'll do
better,
that.
I think.
Is now good. Hello?
Yeah.
What I was discussing was the introduction of section 17A, which has been introduced for the first time. I was going to give you a little history where it was earlier, whether it existed or not. If it existed, where it existed, how the Supreme Court has dealt with it. Way back, similar concept that in case you got to take an action against a public servant, maybe after retirement, maybe during the course when he's on job, with respect to any act done by him in his official duties, if the above the level of joint secretary, then 6.4.1 was a resolution passed by the Government of India, wherein for the persons above the level of joint secretary, the investigating agency first must take consent from the respective authority. This is normally commonly called a single directive. In case of permission is granted, consent is given, then only investigation can be done against a particular public servant or functionary. But mind it, that person ought to be an official of the level of joint secretary or equivalent thereto or above. This single directive philosophy was quashed by the Honorable Supreme Court in judgment called Vineet Narayan's case, whereafter which it was attempted to be reintroduced originally in Central Vigilance Commission Ordinance. Thereafter, it was done in Central Vigilance Commission Act also. But somehow, in Manmohan Singh versus Subramanian Swami's matter, this provisions was under the Supreme Court. Here we are, 17A. It was limited to only Joint Secretary and above. And now today, even if a particular officer, let's take an example, suppose a tender is floated and somebody, that's an authority who's expected to award that contract to somebody, takes up a decision, give it to bidder and to L2 bidder, then in case, even if apparent corruption exists or signs of act showing corruption exist, nobody can invest. Must take permission from the authority to the gentleman. From he done such act. I leave it to you to decide whether this will facilitate the prosecution of in legitimate cases or this will create an option. Minded concept of sanction still exists. So far as have to the authority first before it starts after they have completed the investigation, they can reapproach the same appointing authority by the court can take cognizance of the offences forming part of the subject matter of the charge sheet, obviously with the documents filed along with it. Similarly, there is another provision. Another provision which again I wish to point out to everyone is there was a point decision making or 13(1)(c) of the PCA Act. Today, both the section doesn't exist. I'll just read it for you. What is section 13(1)? Today, what is section 13? To allows any person to do so. It doesn't exist as an on the office.
Hello everyone, we are facing some network issue right now, so give us 5 minutes, we are working on it and we'll get back to it in 5 minutes. Sorry for the inconvenience. Hi everyone, just give us 2-3 more minutes. We are working on the network issue. We'll be back in 2 minutes maximum.
Hello, I believe I'm audible now.
Yes sir, you are audible now.
Okay, I'm sorry. We were discussing section 17A. I believe that I'll redo it because of the networking issue. It doesn't come up properly. Section 17A is a concept which was existing earlier in the form of single directive, which was turned down by the Supreme Court in Legitquest case. Thereafter, it was attempted to be reintroduced in one form or the other by way of an ordinance, by way of an amendment in CVC. Somehow, that also was taken care of by the Honorable Supreme Court in Manmohan Singh versus Subramanian Swamy's matter. But today we have 17A, whereby act of any public servant done during his service, if some investigation has to take place, permission from his corresponding persons, corresponding authorities must be taken. One must remember in this background that this concept of taking permission from competent authority is also mandated by section 90 of the Act, which is normally called as sanction. So today, after amendment, at 2 stages, the appointing authority of a public servant must come in picture. The investigating agency must approach it. The first is before the start of investigation, and the second is after the investigation is over. Then to make the court competent to take cognizance, sanction is required. Everybody is here free to decide whether this is a retrograde step or it's a step which is in furtherance of the Provincial Corruption Act. But there is another provision which one should look into it, and that provision is section 13(1)(d) of previously existing PC Act 1988 and section 13(1)(c) of previously existing PC Act 1988. Both these also deal with the acts of the public servant done by him or decision of the public servant, recommendation of the public servant during the course of his duties. I'll give you an example. You must have remembered a case where telephonic case. I'll not give you the name, though the name is there on my lips, wherein a particular politician was convicted along with his personal secretary because certain decision was taken by her along with the minister, which were not in public interest. That was covered under section 13(1)(d), then 3. Today, that section doesn't exist. Obliteration or removal of those sections, section 13(1)(d), 13C, Section 8, it has come in a different form, Section 9, Section 10, Section 11 in the old PC Act. That old PC Act means PC Act of 1988 has created vast kind of turbulence in the prosecution now. I'll just read few provisions for you so that you can understand how does the new PC Act has affected the common day litigation in the field of Prevention of Corruption Act. I'm reading Section 4 of the Prevention of Corruption Amendment Act 2018, which become effective from 26 July 2018. I'll read for you Section 4. Substitution of new section for sections 7, 8, 9, and 10. That's the heading of this section. Before I divulge further in reading the content of the section, I'll request everybody to look into the word called substitution. Substitution is something which is not a repeal per se, which is not an insertion per se. Substitution, as per the definition of granted by the Supreme Court in Gotumukala's matter, is that I'm using the exact sentence, the earlier existing provision had been scored off and a new provision has been written on it, so that any recourse to take back into consideration the earlier existing provision is not required to be looked into. What does it travel? Where does it travel to us? One way of look at it, this is as if this provision, the earlier provision which should substitute it, was never in existence. I think some of you must be looking towards General Clauses Act and maybe also trying to go into repeal and saving sections of PC Act itself. So let's see first these repeal and saving section of PC Act itself. That's section 30 and 31. Let's go there. Let's see what does they provide to us. I would read section 30 for you. The Prevention of Corruption Act 1947, 2 of 1947 and Criminal Amendment Act 1952 are hereby repealed. So it doesn't talk about section 13, 1 does not talk about PC Act 1988 or the provision which are in existence prior to 26 July 2018. 2 says, notwithstanding any such repeal, please mark these words because these are important to understand the situation which is now coming up. Notwithstanding such repeal, but without prejudice to the application of Section 6 of General Clauses Act 1897, anything done or any action taken or purported to have been done or taken under or in pursuance of the acts so repealed shall, so far it is not inconsistent with the provision of this Act, be deemed to have been done or taken under or in pursuance of the corresponding provision of this Act. Apparently, this means that this is taken care of that proposition which existed earlier, meaning thereby the prosecution under Section 7. This is my interpretation. Please mind it because I'm agitating this issue before the Honorable High Court also and elsewhere also. My interpretation is, I'll read this section again, that the core part of it is, Act so repealed shall insofar as it is not inconsistent with the provision of this Act. So if anything is inconsistent to the provision of this Act, now this Act would mean the present Act as it is after 26 July 2018, not what is existed from September 9 to 1988 when the original erstwhile PC Act, Principal Act was came to be. So the Act which exists today, if anything is inconsistent with the present Act, this section 13(2) will not save those activities. I'll give you an illustration. Please have a look at section 4 of the PC Act, which gives, we must look into section 4 of PC Act, not the amendment one, the main section 4 of the PC Act. And section 4 says, cases triable by a special judge. And now this section has remained as it is, it has not been changed. Now please mind closely what I'm going to read and you have to see. 1. Notwithstanding anything contained in the Code of Criminal Procedure or any other law for the time being in force, offences specified in subsection 1 of section 3 shall be tried by special judges only. In plain language, it means that the special judges appointed under this act has competence to try the offences prescribed under section 3(1) of the PC Act itself. Now, let's go to 3(1). 3(1) says, power to appoint special judges. 1. The central government or the state government may by notification in the official gazette appoint as many special judges as may be necessary for such area or areas for such cases of group of cases as may be specified in the notification to try the following offences. A. Any offense punishable under this act. B. Any conspiracy to commit or any attempt to commit or any abetment of any of the offences specified in clause A. Please tell me, after 26 July 2018, does earlier existing sections 13(1)(d) exist on the statute book? Answer is no. This is in present tense. I'll read the sentence again for you. Any offense punishable under this act as it exists in present, not as it existed in past. So the trial court special judges under section 3(1)(a) can try the offences which are prescribed acts constituting offence under this act. And today, we don't have section 8, we don't have section 9, we don't have section 10, 13(1)(d) and 13(1)(c). The question now arises is, once these sections don't exist on the statute book, and the statute book says that the competent judge can try only the offences prescribed in the statute, can we still continue with the prosecution of the offences which existed prior to 26 July 2018? I'll give an illustration to this aspect. PC Act has two parts. One part of it is procedural. The other part of it is substantive. Substantive means which prescribed an offence. Section 7 primarily deals with practices wherein somebody demands money and whether happens or doesn't happen, but somebody demands money and there is an exchange of money, qua reciprocal promise of giving favor or forbearing to give a favor. That section remains as it is. Only difference in section 7 is earlier word use was whoever. Today the word is offense relating to public servant being bribed, any public servant who. So the now condition of the offense is it is only a public servant who thereafter commits an act prescribed in section A and section B or section C, then only the offense will be made out. If a tout on behalf of a public servant does any of the section 7A or 7B or 7C, that will not be any public servant. It was not in existence earlier. Similarly, if we go by the definition of substitute, I had just referred to Gotumukala's case. I'll give another illustration. I think everybody must be aware of the provisions of Narcotic and Psychotropic Substances Act. It's a reported matter, so I'll share with you. In one matter, offense took place in 1998. Trial was completed in 1999. Appeal came into being in 2015. I'm talking about a Delhi High Court judgment, three rather Delhi High Court judgment. You can take down this particular date and events happening. 1998 offense committed, 1999 conviction held, 99 or 2000 appeal was preferred. Appeal came on hearing in 2015. Similarly, 1998 offense was done. Trial continued up to July 2001. Conviction held, and appeal came to on board on July 2015 only. And third is a case where in January 2001 offense was committed. 2003 conviction was made, and it was in 2015 appeal came up. You won't find a difference otherwise, but I'll tell you what was happening in between. In May 2001, amendment in NDPSS took place, whereby punishment clause the amendment was made by way of substitution in the punishment clause, and for certain particular quantity of the NDPS, if held by the accused or the suspect after trial, punishment was reduced from 10 years to 5 years. I've given you three situations. One, trial over, conviction held in 99, appeal pending. Two, trial was pending when in May 2001, amendment came in, conviction was in July 2001. Third, in January 2001, offense was committed, 2003, conviction held, and appeal is pending. Do you know, for all these three persons, benefit of the amendment was given to accused persons in appeal, meaning thereby, you want the citation names, I'll give it to you. Meaning thereby, it was all three judges' judgment was by Justice P.S. Teji. I can share that. I remember that kind of a judge. So there is other judgment also, judgment from Rajasthan High Court itself. So what was held was that in case of an amendment, if certain benefit is accrued to accuse or to convict, they must be given to it. But for PC Act is concerned, I am seeing something else also. Apart from this mauling effect, that is word normally used in the legislature, mauling effect, which you also find with respect to provision of 428 CRPC. In, I believe it's a PRA's case, wherein such benefit was given post-conviction, years after post-conviction. But my case somehow today, when we are discussing only PCI, is different. Kotumo Kalai is a matter in which the Supreme Court Justice Sikri's judgment is there, has held that substitution, para 15 I believe, that judgment is para 15. That substitution is not equatable to either repeal or any other equivalent. Because it is doing two acts. It is removing also and substituting also. And we are not in a position per se, because of the judicial interpretation, to say that we can still continue with the old trial. I'll give you one more illustration in this aspect. After 26 July 2018, that's an issue of research which anybody can do. All new charge sheets which are being filed with respect to the public servant who have offices much earlier to 2018 July, sanction are being sought from their respective appointing authority. And look at the logic. If I committed offense somewhere prior to July 2018, 26 July 2018, you investigated, I even retired prior there to. So if you are filing charge sheet for me under old PC Act of 88, you never required, before 25th July 2018, you never required any sanction to be taken from my appointing authority, because then the provision was is. Even if you look in the Prakash Singh Badal's judgment, even in that judgment, it has been held that in case a public servant had changed the office, meaning earlier he was an MP, thereafter he became an MLA. At the time of taking cognizance, he was an MLA, no more remain an MP, or vice versa. Then since the public servant is not enjoying in office, no sanction is required. But now, even in the old cases where investigation has taken place, charge sheet is being filed after 26 July, in each of the cases, sanction is being done. I put this question to myself and I asked everybody of you, if the provision of sanction would apply retrospectively, section 19 would apply retrospectively, and the prosecuting agencies are acknowledging that fact, how can anybody say that the remaining procedural aspect with respect to definition of offences, we will not give a retrospective effect? I think I must elaborate so that you people can understand it part of it. Earlier, to take like this concept of sanction, or what is the procedure, or what is the offense, I'll distinction all these three things. In view of the amendment happened in July 2018, Prior to July 2018, you can use this particular method. There were two streets, two ways, or two means whereby the special judge can take cognizance. After seeing the charge sheet, he must go through the charge sheet and put a question whether the accused person is a public servant. If the answer has come yes, he will have to ask the second question, is he a public servant or he was a public servant? In case he finds that the answer is that the person is accused is public servant, he will then look into the sanction order. It's there or not there. If sanction order is there, yes, of course you can take cognizance. But if sanction is not there, he has no power to take cognizance. So charge sheet will though remain filed, but he will not proceed under section 309 CRPC, 309(2) CRPC. So it will remain as it is. If the public servant at the time when he is looking into the charge sheet, taking cognizance, applying his mind to that limited aspect, whether to take cognizance or not, the public servant is not in that post. He was not required. I'll answer that question also, which is coming up. He was not required to look for sanction and he will simply take cognizance. Today, this bypass route that ex-public servant can be taken cognizance has ceased to exist. So for everybody, cognizance has to be there. If that's a scope, one hand. And now see what does sections talks about. I will now explain you criminal misconduct and then tell you which portion remains, the procedural, and which portion is talk about the offense. Because there is a confusion. I also have to look in hard into to find answer of this, that which portion of section 13 or for section 7 is a procedural part and which is substantive part. Let's read section 13 once again. Section 13 after the amendment is there. It starts with the word called criminal misconduct by a public servant. It says, a public servant is said to commit the offense of criminal misconduct if he dishonestly or fraudulently misappropriate or otherwise convert for his own use any property entrusted to him or any property under his control as a public servant or allows any other person to do so. Now, let's answer this question, which is an offense and which is the procedure of the offense. Obviously, everybody of you must be answering. Offense is misconduct. A of that said B, I'll read B for you also, defines the facts which are required to be proved to show that offense of misconduct has been done. Now, if these are facts required to be proved to establish happening of criminal misconduct by public servant, then this constitutes evidence. Or this is the procedure. It is not. So content of A are not substantive offense. They are either defining the procedure whereby facts can be placed and offense can be established. Offense is what? Misconduct. Similarly, B, if he intentionally enriches himself illicitly. So this is also a way, or this is also the bundle of facts which one must prove. So by proving these facts, you are proving the offense of misconduct. Just have a look at 13(2) also. Any person who commits misconduct, criminal misconduct, shall be imprisoned. So the punishment is for misconduct. Punishment is not that you intentionally enrich yourself. No, enrichment constitutes the offense of misconduct. So the prosecution must prove the evidence constituting acts of misconduct. Definition of offense would be murder, would be criminal misconduct. Let's take further example and try to test it otherwise. I'll read for you section 11. Punishment for abatement of offenses. Whoever abets any offense punishable under this act, whether or not that offense is committed in consequence of that abatement, shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years and shall also liable to be fined. Here the offense defined is whosoever. So requirement of a public servant is not here. So anybody who abets a public servant for committal of any offense. Why I'm using the word public servant is because the offense must relate to PC Act. And if you go through PC Act, Section 7 also talk about public servant, 7A does not talk about public servant. Then Section 8 is again dealing with public servant when somebody bribes public servant. That is a reverse step we normally call in the our daily language, which we use in the court while doing the prosecution or defense of the accused persons. 9 relate to of bribe related to public servant given by a commercial organization, and 10 relates to that the official, the person concerned of that commercial organization who's in charge would be held guilty of the offense. 12 talks about abetment of the same day. But since today's discourse is limited to the amendment, I'll go back to you again with respect to amendment. In amendment, if you again see the word substitute for all offenses, Section 4 of Amendment Act, you can write down few things. If you look into the Black's Law Dictionary at page 1281, word substitute has been defined to mean to put in a place of another person or thing or to exchange. Once it is an exchange, it will go back to stage 1. Similarly, Collins Law Dictionary, Collins English Dictionary, the word substitute has been defined to mean to serve or cause to serve in places of another person or thing. The Supreme Court in Gotu-Mukalas has held, ordinarily whenever the word substitute or substitution is used by a legislature, it has the effect of deleting old provision and make the new provision operative. The process of substitution consists of 2 steps. First, old rule is made cease to exist, and next, new rule is brought into existence in its place. The rule is that when a subsequent act amends an earlier one in such a way as to incorporate itself or a part of itself into earlier, then the earlier act must thereafter be read and construed as if the altered word had been written into the earlier act with pen and ink, and the old word scored out, so that thereafter there is no need to refer to the amending act at all. This para 15 will go to Mukala. If we read this, it has brought the entire prosecution of PC Act as it was existence on 25th July 2018 in tipsy-turvy kind of a thing. It will happen even in the appeal also, because appeal is an extension of trial. First appeal is an extension of trial, second appeal of obviously SLP doesn't mean extension of trial. Similarly, if we further travel with respect to amendment, the judgment which I was talking about for CRPC was Boucher Pierre Andare versus Superintendent Central Jail. Now you can have all the judgments, whatever you wanted to have. Section 428 was introduced, and it was held that on a plain and natural construction of its language, posit its applicability, a fact situation which is described by the clauses where accused person has on conviction been sentenced to imprisonment for a term. So it is irrespective. It was held that it is irrespective as to whether that imprisonment has happened after the amendment is there of 428 or it has been prior there. So this Boucher Peter Andare, Superintendent of Central Jail, is one of those judgments which has dealt with the provisions relating to mauling effect. Then please also appreciate Section 4 of the PC Act. We're talking only limited ourselves to the extension. Section 4 of PC Act rules out something more. It says I read already 4.1, I'll now read 4.2. Every offense specified in subsection 1 of section 3 shall be tried by a special judge for the area within which it was committed, or as the case may be, special judge appointed for the case, or where there are more than special judges than one, then such area by such one of them as may be specified in this behalf by the central government. So again, the word used is shall. It shall be tried by. So it is creating an exception to CRPC. You must remember that special judge in PC Act is an additional session judge or additional district judge. It is not MM. And it is a court, which is normally called an amalgamated court, having the power of magistrate as well as of session judge, because the FIR is lodged here, remand proceedings are also done here. Without commitment of the accused person, charges is directly filed here. If you want to take a reference, R.S. Nayak versus Madhulime, 6th judgment, I believe. You can find a particular paragraph dealing with this proposition that the special judges hold the power of a magistrate and it is an amalgamating court. Once we held that, but the Supreme Court has held that, this means the provision of CRPC, so far as this portion is concerned, will not be applicable. What will apply is Section 6 I have just read of General Clauses Act will not apply, because today provisions of earlier 13C and 13D are not in existence in statute books. So, for these two provisions, now the law is inconsistent with the earlier provisions. So, the law must give way. Today's provision we have to look into. Then we can always safely rely to Section 31 also of the PC Act, which says, I've read you 30 and 31. Omission of section of, it also talks about 161 and 165. Omission of certain section of Act of 45 of 1860. Section 161 to 165A, both inclusive of the IPC, shall be omitted, and Section 6 of the General Clauses Act shall apply to such omission as if the said section has been repealed by Central Act. 6 will apply, but what does 6 say? 6 of the General Clauses Act, what does it say? It says, again says the same thing, which is also available in Section 1332, which says that if something inconsistent exists, so the definition of the clauses by themselves says this inconsistency has arisen because those two particular sections stood completely obliterated. Now, if somebody wants to take a question on the amendment, because I can continue for hours together on the issue of amendment, but I wish to take a question first. It's already 10 minutes for 5. Any questions?
Thank you, sir. That was very insightful and helpful. Now we'll take up the questions that we have with us. The first one is regarding the concept of protection of whistleblower in Prevention of Corruption Act, and how far the identity of whistleblower should not be disclosed.
I deliberately omitted this particular section because this is a section which is yet to be given practical effect to, and this section primarily relates to something which I personally don't feel that it should be there in the Act itself. I read for you the section itself. Any other those questions in the meantime?
Okay, should I ask the other question?
Yeah, do that.
Yeah. The other one is regarding the gratification. What is meant by taking gratification for showing or forbearing to show in the exercise
gratification,
of
I'll explain. Gratification in nomenclature or in general dictionary language is something which gratifies me. It is not which is legally I'm entitled for. It could be in money, it could be in kind, anything to gratify me. You must understand gratification relates to only this. Simple meaning of gratification, that something which gratifies the person's will or acts is called gratification. Should I say that apart from taking money, there are instances where facilities has been taken. Facilities like, I wish to go abroad, somebody is buying ticket for me and I'm a public servant. Even buying ticket, going abroad, even that will constitute gratification. So the concept is clear. It could be in cash, it could be in kind. And it should be legal. I am not legally entitled to have it.
Okay, so thank you. Now, the other question is regarding corporate liability of commercial organizations.
No, that's a very exhaustive subject. I can only give you brief answers.
Yeah.
Criminal corporate liability, which earlier was a maxim only or a concept only, now it has been brought into statute book. We read section 9 for that sake. It says acts have been committed by a commercial organization. Such organization shall be punishable with fine if any person associated with such commercial organization gives or promises to give any undue advantage to public servant intending to obtain or retain business with such commercial organization, etc., etc. Commercial organization per se would be an accused. Supposing there is a limited company or there is a partnership firm or there is a proprietorship firm or there is a private limited company. That company which cannot do anything. See, company doesn't have menseria of its own. Menseria of the company is with the person who are in charge of its working concept. Even despite of that, now today it will be an accused therein. And let's go a little further also. We read 10 also. That's why I tell that it's a very ticklish object which has now come up. Person in charge of a commercial organization to be guilty of the offense. Please read it carefully and understand what does it says. It's a common English, nothing technical about it. Where offense under section 9 is committed by a commercial organization and such offense is proved in the court to have been committed with the consent or connivance of any director, manager, secretary or other officer shall be of the commercial organization. Such director, secretary or other officer shall be guilty of the offense and shall be liable to be prosecuted against and shall be punished with imprisonment or it may not be less than 3 years. What does it mean? It means once it is established that a company or a partnership firm or a proprietorship firm has committed the offense of 9. If you look into the Companies Act, all directors, firstly, even the manager or the persons who had been authorized to do an act. I'll give an example. I'll give an example which is there in the judicial pronouncement itself. There was a company in UP. He was having some tax issues. They were dealing with some product which was under Custom and Excise Act, particularly Excise Act. The MD of the company, on the request of a senior officer in that excise department, sent some money through a particular person to give that money to another person, that excise officer. Earlier, you can take a scapegoat that, sir, I didn't know that what is contained therein, and therefore I'm just a delivery man, so please excuse me because it's a conversation happening between me and see, I'm only carrier. Now, if it is proved that the public servant or the person who is sending the money had informed the gentleman that this is the money which we are giving because of X job, irrespective of the position of the person concerned, he will be responsible in section 10 of the PC Act. It has enhanced the scope of PC Act, but I again say it has enhanced 9 and 10 enhanced scope of PC Act, not co public servant, but co private persons only. So that's my particular answer. Anything else?
Yes, sir. Thank you for that. Now, the other question is that the definition of known sources of income permits public officials to claim lawful income from variety of sources. As it defines, it is income received from lawful sources. So,
please understand this concept again. It was an explanation available to section 13, earlier 1E. Today, that explanation is an explanation to section 13B only. It's an explanation 1. I'll read for you first the explanation. Explanation 2, sorry. Known source of income means, please mind the words carefully. Income received from lawful source. Income received from salary, it is not written here. Public servant normally receives income from salary. But does this section says income received from any lawful source. So salary is not the only source whereby the public servant receives income. It says lawful source, meaning thereby, if I am a son of a particular person, so let's take an example. I joined public service on 1st January 2020. I'm making a house of 400 crore rupees. And on 26th January 2020, I resigned from that particular job. Do I am entitled to have a salary? Answer would be yes, you are entitled to have at the best 25 days salary. But because of my previous financial involvements, I have sources to make a house of 400 crores. This will be my lawful source. This is only one example. It could be many. If I inherit something by virtue of partition, by virtue of division, by virtue of will, that's a lawful, that's prescribed in law. I receive something as a gift, which I intimate to my department that because of my relations or because of this X activity, I had received gift and I had intimate, I'm making intimation and the department accepts it. So even those kind of things becomes a lawful source. Take another example, go far-fetched. My son works somewhere. He sends me money. I don't know from where he sends. He works somewhere abroad. He sends me US dollar. Credit to my account. There is no link that any offense is committed in India. So far as the public servant is concerned, it may be a lawful source, provided the activities of son are not prohibited. And son is adult now, not financially responsible only. So one must understand, word use is source, lawful source. Word use is not salary. So please don't equate known source of income means income from salary itself. And what is the meaning of word known? Known means which the prosecution happened to know. From where the prosecution will happen to know what are my known source of income? It's only one place, my personal file. The manner in which I give my annual property intimation or intimation of acquiring the property, intimation of receiving gift. So those intimations are sources which are known to the prosecution and are known to everybody. So must focus, word use is known and word use is lawful resources. Don't equate with the salary or pay. Anything else?
Yes, sir. The other question is, in what circumstance 17A of the PC Act is applicable?
Today, if I've taken any decision, let's example, a notice invited tender has been floated by, say, some civil construction. Let's take CPWD. In that CPWD notice in NIT, certain person filed their tenders. Tenders are opened up. There is a process called justification for the tender is concerned. Justification means that I will sit along with the person concerned, the person who has filed the tender. I will sit with him. I'll discuss that you have brick rates, you are too much, iron rate you must reduce. So that's process called justification. This I will do with the market survey which I've already done. My department has already done. If after that justification, I find that the person who has given the L1 quotation is not up to mark, or I got some other information that he has been not discharging his contractual jobs as efficiently as done, and I'm not giving contract to him, so I give it to L2. So that's a decision, conscious decision taken by me that despite of the rule book, despite of the codal formalities, I'm not awarding contract to L1 for X reason. Earlier, this act without any check could be converted into an act committed by me under section 13(1)(c) or 13(1)(d) of the PC Act, criminal misconduct. But today, the investigating agency, even before starting investigation starts the registration of the FIR. So take it that way. Before starting investigation, must approach my appointing authority, whether I'm working or I'm retired. They give him facts that on this fact we intend to investigate. Then the authority may or may not give the permission, but if it gives the permission, then only the FIR can be registered and thereafter the investigation can be done. So that's a difference 17A has done. Any other question?
Yes, sir. The next one is regarding sanction. Can you tell us about the law of sanction in the PC Act? Is sanction needed before the commencement of investigation or after? What is the stage of taking sanction?
It is after. Sanction is something which after the investigation is over. Then you see, please understand why concept of sanction has been introduced in PC Act also, and it exists in CRPC also. Section 197 of CRPC deals with the sanction. They are almost perimeteria provisions. At least today they are perimeter because in 197 is or was, irrespective whether the person government servant is in service or not in service, sanction, you have to take a sanction of 197. Today in PC Act also the same position is there. And sanction is required. I'll tell you the reason of sanction is. Supposing, take the example which I was just taking, continue with that example. It is my department. Supposing I'm in CPWD, I don't give contract to L1, I give contract to L3 also. Or I record the reasons in the file. Who will be the person, not the investigator, IO, who's the inspector or DSP or prosecuting agency? They may not be able to understand the reason why I have not given the contract to L1 or L2 straight away jump to L3. It is my department, because that's a specialized agency which knows how work in this agency has to be done or has been done. So my superior, my appointing authority would be able to appreciate as to whether this act of public servant in fact tantamount to a act which is unbecoming of his duties and constitute criminal misconduct, or it is just a conduct. It was required at the relevant point of time. Understand like this. I think everybody must have gone to thesis. There was a bridge under construction which continued under construction for say around 25 years. It is today constructed. Attempts were made, obtained number of times, to record certain, investigate certain anomalies with respect to which 25 years has taken instead of their making that bridge, but not otherwise. Now this was an session. FIR was not registered in that case. And now I think everybody must be knowing there's another bridge connecting Delhi to Chandigarh, that is a bridge called Mukarba Chowk. When that bridge was constructed, CM was expected to visit. They found that taking right or taking left turn or going straight, because of the spread of the road, cannot be managed. There will be hodgepodge situation of the traffic. So urgently a request was made to plant certain plastic cones over the road. Now that plastic cones do vary from quality of plastic, whether they have 3M film they are on, there are multiple things. CBI registered a case on this. I think 8 to 10 CPWD officials who had overnight worked to make that bridge operational, Mukarba Chowk I'm talking about, operational, had faced the trial. After about 6 years, because I was conducting the trial, after 6 years, the court has acquitted them by holding that the situation at that point of time, within 3 days, you have to make bridge operational, and this hurdle was existing, and this was admitted by the sanctioning authority itself when it comes to grant the depose about sanction. We pressed upon them to complete the job, and that's the reason why tender was not invited. So for protecting these innocent persons, for protecting the person who know how to get the job done, we need a person from that fraternity only, not otherwise. So that's the reason why concept of sanction is there. It's existing since 1947, and it was in existence since 1973 also, because even in earlier PC Act, which is I think of 1898, concept of sanction was there with respect to offense of IPC section 161 to 165. So it is a healthy section. It must remain as it is. That's the concept of sanction.
Okay, sir. Thank you. The other question is, what is the connection between PC Act and Disproportionate Assets case? Whether the 2018 Amendment Act has weakened the strength of the Act?
Now, these are two questions. These are not one question.
Yeah.
First question is disproportionate assets. Anybody during the period of his service, maybe 5 years, 10 years, because the minimum case which I am facing is in which within 3 years, it was alleged for me that I had assets beyond nonsense of my income. Concept is that whatever government servant receives as lawful sources to proceed, his assets must be according to that only. Meaning thereby, let's take an example. Supposing between 2010 to 2020, my service book says that apart from salary, I have received this many gifts in my own capacity. Please remember this thing first. In my own capacity, in my own name. And Y quantum of assets has been generated in my wife's name. Those wife's assets cannot be generated by from my earnings. So if we combine together, then those value of those assets will go far beyond my earning capacities. My earning capacity, public service earning capacity. So apparently you can safely say that yes, here is a case where the person earns rupees 100 and his assets are rupees 200. So it's a clear case of disproportionate assets. But please understand there are riders. CSS conduct rule provides, I believe it is 16.3. It says that public servant is not required to intimate what his spouses or children obtain or acquire about assets from their own sources, irrespective of the sources of the public servant. This is one. I think you must go, people must go through the judgment of K. Basasaran versus DSP Chennai. In that judgment, the Supreme Court has held that when the wife has come up with an explanation that all unaccounted money found available at their house and the assets found available at their house is her ill-gotten money for which he earned by doing a trade for which he has neither purchase vouchers nor sale vouchers nor account books. And income tax people have accepted that money to be legitimate money at the hands of the wife. It is very difficult to treat that the money in the hands of the wife would be money in the hands of the husband. So in that case, acquittal was done. Similarly, there is a SS Kari, Suryakant Kari, S. Suryakant Kari judgment. Go through the judgment also. In that judgment also, the explanation tendered by the public servant that his wife, his son, and etc. are holder of this property, and he is not the holder of this property. They generate this property from their own sources. It was accepted by the Supreme Court that yes, in such a situation, you cannot hold that the assets of the public servant are not justifiably from lawful sources. Please understand, concept of source. My wife getting property is a lawful source. My son getting property, earning property is a lawful source. If my son is going to do a dacoity and earn money therefrom, then the source might be illegal. Lawful means which has been generated, accounted for, and available on records. So that's how we perceive section earlier 13.1e or now 13.1b. That's a disproportionate assets. Achha, you talked about one more thing, no? What the other question was? Weaken or strengthen?
This question,
yeah.
We have this from one of the, yeah. So he is asking that it has weakened the strength of the act or strength.
I'm still struggling to find somebody who disagree with me that it has not weakened. See, why you are introducing section 17 when you have section 19, 17A when you have section 19 also? If I have, see, there are other judgments. If somebody wants to read, there's A. Siva Kumar judgment, Siva Prakash judgment, C. Siva Prakash judgment, Supreme Court only. I think state of AP this is judgment. In that judgment, the old concept of 1948 was pre-propounded that as a government servant, I did not adhere to financial code. I did not adhere to service regulation. I flouted office order. Even despite of this proposition, I cannot be said to have committed offence pursuant under erstwhile section 13.1d of the PC Act. So if that situation was existing in the pre-amendment stage, today we have a specific section which prohibits even the investigation also. I think I must share something more with you. You people might have read of or heard of a act called Delhi Special Police Establishment Act. If you have not heard, please go through it. It's a very small act. It is an act under which CBI was constituted. In fact, CBI was not constituted in this act. CBI was constituted on a very peculiar day, which everybody must enjoy. It was constituted on 1st of April. I will not name why 1st of April is famous for, apart from being the birthday of CBI. 1st April 1963. It was created by Government of India's resolution that there will be an institution called Central Bureau of Investigation, which will be an institution of the DSPA Act. There also there is a concept of Section 5 and Section 7. It talks about that for investigation, certain consent has to be taken. So Section 17A, Section 5, Section 6 of the DSPA Act, they talk about, they deal with the hemisphere where investigation is yet to start. So you can't even register an FIR against me in case you have not taken consent or under Section 5 or 6A. That relates to, obviously, that relates to public servant under the domain of the state government. So 17A is one concept. Second concept is or was in Section 19. Third is removal of Section 13(1)C, 13(1)D. And there are plenty of other NOSAs on which I believe this section has been brought down. What else?
Okay, so this is the last question that we have. How do you think the government is handling sham or shell companies which are used as a wheel to conduct various illicit tax evasion and money laundering activities?
These are absolutely new concepts. And see, PC Act was introduced in PMLA in June 2009. Prior thereto, the general offences of IPC were existing. There are certain other offences which are existing as Schedule A of the PMLA Act. But sham companies and other dubious entities which exist today would now have to be covered somewhere between PC Act also and as well as under the PMLA Act also. Government is doing, but it's a beginning field. There are a lot of errors and a lot of misguided. I think I must share with you this proposition also. Last PMLA amendment was done under the Finance Act. Can you believe that? You are amending PMLA Act by introducing the provisions that the complaint, original complaint, which is commonly we call OC, can be filed at multiple point of times. Meaning thereby, so I'll share a case with you to highlight the position. An ECIR, Enforcement Complaint Information Report, was registered against me at Delhi office of PMLA on the basis that the CBI had filed a charge sheet against me for having assets disproportionate by known source of income, and they attached one of my property at Gurgaon. Then they register another ECIR without disclosing that they already registered a ECIR in Delhi at Chandigarh. They started proceeding therein and attached some of my other properties which are existing either in Chandigarh or in other part of Haryana. Issue today is, and they file a fresh OC. Today issue is that prior to 2018, when this amendment was not there in PMLA Act, which was done under the Finance Act, and if you look at the general law, you register an FIR against me, which is obviously akin to first information report, and it is equal to ECIR registered by PMLA, saying that yes, this particular person has committed offense, a scheduled offense, charge sheet has been filed, so we are initiating this process. Whether in that report, all offenses, all acts committed by me, which the charge sheet has been filed, are not taken cognizance of by you. Can you do subsequently? But see, the government has to amend the law, and today the government is saying that subsequent multiple filing of the original complaints are legitimate. This is the latest amendment in PML. So I'm only saying government has to still travel afar off. They are trying, but coherent attempt, I'm sorry to say, is not being done. Sham companies you cannot control, because sham companies are made, because I'm dealing with those companies also. They are, supposing their company is made prior to 2018, it acquires a property prior to 2018 and does not do anything else. How you are going to say that offense committed by it prior to 18, though we had knowledge today, would be a part of the crime proceed made in 2018 onwards? So I believe PML have to substantially amend it, maybe repeal altogether and get a fresh act, instead of doing this patchwork by making amendment after amendment otherwise.
Okay, sir, thanks a lot. That was really insightful. Is there anything else you would like to add in the end?
No, I'll just say one thing, that PC Act is one of the smallest act, having only 31 provision, and it is one of the most exhaustive act. Life will spend upon interpreting the provision of these 31 sections. One should do labor on it and read the sentence carefully. That's my message for everybody. Thank you very much.
Okay, it was wonderful to have you here, and we appreciate you being here. Thank you for your exceptional views. Stay safe, everyone. Thank you to the attendees and the participants as well. And for the recording, kindly subscribe to Legitquest YouTube channel.
Thank you very much.
Thank you.